This case is a breach of contract case in the trial court. County sued Gilbane, the general contractor, for breach of contract. This relates to the 2010 construction and renovation of the spring training facilities for the Baltimore Orioles here in Sarasota, primarily Ed Smith Stadium. Part of the project called for upgrading and adding to the concourse areas of the stadium where all the amenities and the hot dogs are sold and the peanuts and Cracker Jack. Part of that is concrete flooring. And when the concrete floors were initially installed, there were issues with the floors. There was cracking in the floors. It was not the aesthetic that the Orioles or the county wanted. So, and this is important because after that happened, the parties got together and decided and came to an agreement to do something better, to do something more. They entered into an interim field change agreement to repair the floors and apply something called methyl methacrylate, which we'll call MMA for purposes today because that's a tongue twister. The MMA is basically a top coat that gives you that kind of that shine and that real nice aesthetically pleasing look to a floor. And this was added to the contract, the IFCAs. They're incorporated into the contract. And in 2012, 2013, Gilbane endeavored then to apply this flooring type. And the installation took place.
Before it got to that point, there were some discussions as to whether that product or other products should be utilized, correct?
Yes, there was. And
ultimately the Orioles and the county entered into the agreement saying, this is the product, go forward.
Yes. And the contract then included language, and there was more of a generic language because it did allow for substitution that, is a generic MMA. There's not just one type of MMA.
Yeah, but didn't Gilbane offer a substitution that was rejected?
Yes.
Okay. How is that their fault? They applied what they were told to apply. And what appears to be undisputed is they applied it correctly, according to the specifications. And then once it didn't work, your client hires Prim USA to apply something with the same results. And the conclusion is water intrusion.
Correct.
So we have a trial where is largely the credibility of the witnesses, which we can't toy with. We can't second guess the trial judge who sat there, personally observed these people, and made certain rulings that unfortunately your experts weren't qualified, they weren't prepared, and they didn't have the credentials. So help us out.
Well, thank you for that, Judge. It's not as quickly you go from the 2012 installation to the county hiring premise. There were efforts being made after the first failure of the floor. Gilbane endeavored to try to fix it. There was a couple of efforts to do that. They didn't work. And again, just like when the initial installation of the floor takes place in 2010 and the cracks appear, the opportunity was there for the parties to come together and develop another agreement to do something different.
Well, when they had already suggested an alternative and it had been shot down, they don't have a legal duty to offer a second alternative, do they?
Not legally obligated, but at the same time, they have not delivered the floor that they promised us in the contract.
But you agree that the alternative that they suggested, that they said was more appropriate for the climate of Florida and not Camden Yards, Baltimore, your client and the Orioles rejected. Correct.
That's correct. Yes.
Okay. Go ahead.
And again, that's in a different time. Now we have both the parties have the education of experience now and the issues that happen on the floor. And now we're at a point where we have not received the floor we were promised. Clearly, there's an issue with the materials to be installed. And instead of
Wait. You
Sure,
just said
sure.
clearly there's an issue with regard to the materials to be installed. But that was not what you argued to the trial court, right? Your theory of the case
That's-
below was that there was an issue with the way the materials were
Yes,
installed.
yes, yes.
That was the case you argued in the trial court.
That's what we did. Yes, yes. I may have misspoke there. The issue was the finished product was not what the county was seeking here. So again, there's this, instead of trying to come up with a solution, it was simply to, walk away from the project. And again, the county was left to self-help. The county was able then to hire premise, as Judge Sleep mentioned. They were able to use a variation of the same type of product that would have been approvable if Gilbane had come to us with that, certainly, or if we had
That's interesting how you say
to
the
make
county,
another IFTA.
you say the county used self-help. I just don't see it because the Orioles paid the lion's share of the expenses, as did Gilbane. As I can tell, the county paid a pittance of $55,000. I don't see any damages here either. So what's the self-help that you're talking about? Did
Well,
they just call the Orioles and say, hey, it didn't work, give us more money for a third application?
If it only were that easy.
Well, it sounds like that's what happened.
Well, no, I mean, the county did have to spend $1 million to have Primus take up the flooring completely and reinstall it, basically. Take it down to its base level and then reapply level by level the coatings and the top coat at the end to get a floor that is to this day still in great shape.
And
All
did you
of which
prove by,
flows-
did you,
Hang on, Judge Sleep, all of which flows from the decision of the Orioles and the county to proceed with the original product.
Yes.
Okay.
did you prove by preponderance of the evidence that the alternative suggested by Gilbane would not have worked?
I don't believe that was the case necessarily.
So where's the material breach?
Well, the floor was not to the county's standard.
Well, that's the materials
promise-
you require.
True, but again, the opportunity to have the parties, again, their IFCAs were done in this project several times, including for this particular aspect of the project. Nothing prevented another IFCA from being developed in this case. Again,
So you alleged below that Gilbane breached the contract by failing to fulfill its obligation to recommend a different product. That was the theory of your case below.
yes,
That's what you're telling us here? That's the issue that was litigated below?
that was an issue to litigate, but at the end of the day, the issue is that the contract called for them to give us a floor that the county and the Orioles would be pleased with. And the contract, required them to,
But you can't just file a complaint that says we didn't get what we wanted, therefore pay us. I mean,
true.
So you keep coming back to this blanket statement that seems to encompass every argument that you feel like making. But you're telling me that it was specifically alleged and argued and everybody understood, including the trial court, that the issue to be resolved was whether Gilbane breached its obligation under the contract to recommend an alternative product.
Yes.
Okay.
And again, the key issue for us in this case, and it was a main point and focus of our briefing, was that the trial court interpreted the contract between Gilbane and the county not as it was written. That contract allowed for substitution that with procedures to do that.
But what you're suggesting is the court should have read it as a mandatory requirement that Gilbane substitute a product that was not consistent with the product that had been directed to be used by the Orioles and the county. And the contract doesn't say that they are undertaking any design obligations or any scientific testing obligations, does it?
No, but the court said in this
It
case,
says put down a floor using this product.
well, this type of product. MMA is, it's not just one type of MMA. It's
But the product that ended up working was not MMA, correct?
It was.
I thought it was a
The
different.
bottom layer of the product was a urethane-based bottom layer as opposed to a epoxy-based layer. But the remainder of the layers above that and the top of it's MMA.
But the spec sheet and the BASF requirements, that BASF actually wrote an email about saying, this is the one to use. And then your clients agreed with that recommendation from BASF, not your
Yes.
clients, the county
Yes.
or the Orioles, right?
Yes. Yes.
Okay.
Yes.
All right. You
again,
did not
coming back-
request any rebuttal time. You have a few minutes before you get there. Do
Sure.
you want to reserve any?
I'll reserve maybe 2 minutes.
Okay.
So again, coming back to the contract itself and interpretation of it, the quote from the judgment that gave the county the most pause was the quote is, once the county issued the IFCAS requiring the use of the BASF MMA with MT240 VB product, Gilbane was contractually obligated to follow that directive. The contract did not require them to use that particular combination of products. That it required them to use MMA. It allowed for substitution. You know, this is not the same as Gilbane's contract with its subcontractor, which locked them into, you will use this product and this product only, and this singular combination of products only. Again, the contract allowed for alternatives before failure, after failure, whenever.
Mr. Bussard, you're starting to repeat the arguments. I think
Sure.
we have a pretty good handle on it. Is there anything new you want to add?
No, not. I don't think so. I think I'll save for rebuttal time.
Very good.
Thank you, Your Honor.
Thank you. Mr. Dart?
Thank you, Your Honor, for please the court. My name is Tom Dart from the firm of Adams and Reese. I'm here on behalf of the Applee Gilbane Building Company. Let me say at the outset, Your Honor, that there is no question but that this case was tried below under the theory that Gilbane and Hunt, its consultant, misapplied the prescribed product of the BASF MMA. If the court reviews the final judgment of some 19 pages, which was exhaustive in the analysis by the trial judge of the testimony, not only of the experts, but of the factual witnesses, there is no mention of any obligation or insistence that another product be used other than the urethane, other than the MMA product and the Mastertop 240 VB, which was prescribed by the architect and BASF. It was clear from the outset by the Orioles that the BASF product was a selected product, and they insisted upon its use throughout, despite other information that was available to them for an alternative product, which eventually was used by Primus USA, which was the urethane-based moisture prevention system. So that the attempt now by the county to circumvent a 6-day trial where some 18 witnesses and nearly 60 pages of exhibits were offered, and a thorough review by the trial court in its final judgment that now this is not the right product and that all along the other product should be used, we would contend is disingenuous. In fact, there was no confusion by the trial court as to what the particular provisions and warranties were within both the prime contract and the IFCA. It is very clear from the prime contract that that it was required to use the BASF MMA product and the Mastertop. It states in the contractual provisions that they cite in their brief that when a singular service process, product, material, equipment, or method of construction required by the contract documents, the one specified shall be used. There are very narrow exceptions to that, where the contractor may offer another product for consideration, which it did prior to the time that the construction was undertaken. And there are 3 criteria for that. One is when the specified product or processes are discontinued or otherwise not available, which is not the case here, nor is there any evidence that it was. The third consideration is when such substitution, in the opinion of the architect or the representatives, is otherwise in the best interest of the county or the Orioles, the contract, the testimony and the evidence was directly to the contrary. It was the Orioles, it was the county, and it was their architect that prescribed the particular MMA and the master top. And then the third would be when in the judgment of the contract manager at risk, this specified product or processes will not produce the desired result. There is absolutely no evidence other than the suggestion of alternative products that was the case. In fact, it was still contended by the county and the Orioles that the particular product they had prescribed was valid and appropriate, and the numerous reapplications that were made, both by Advanced Services as well as by Primus USA, until, as Pat Calhoun was a stadium representative, said, we finally determined that this was the definition of insanity. We continued to do the same thing over and over again, expecting the same results, which was not appropriate. I think that any contention to the contrary is belied by the testimony of its county representative, Carolyn Eastwood. She was the project manager in charge for the county who directed the construction. And she said unequivocally, and it's cited within the final judgment, that if BSF MMA was not an appropriate product, Gilbane would not be responsible for the failure. I think that sums up Gilbane's position on this. I won't belabor the issues we have raised in the answer brief, nor the questions the court has already posed to the county, and I would entertain any further questions should the court have any.
Mr. Dart, it doesn't look like there are any questions for you. Thank you. Mr. Bossard, you have 2 minutes for rebuttal.
Sorry. Thank you, Your Honor. Unless the court has any other questions, I think I would simply, on the county's behalf, ask for reversal of the trial court's decision below.
Very good. Thank you, Mr. Bossard. Thank you, Mr. Dart. We appreciate it. You may exit the courtroom. I'm going to take a moment to see